I thank you for joining. I thank you for your support, your comments, your questions. Subscribe to my YouTube channel, like and subscribe to my YouTube channel. Continue to follow me here on Facebook Live, and certainly share the shows and share my page with your friends and family, people who would like and enjoy this platform, as well as would have questions or comments or some issues that they would like to discuss here on this platform. As you know, you should know by now. I hope you know by now, but if you don't, Wait One Legal Minute is a platform to discuss legal issues, social issues, anything you want to talk about. I'm doing it live. It's taken me a long time to get to this point that I am sharing what I know about legal issues, mainly family law issues, and really just stepping out there in front of the camera. Not a pre-recorded session. Some of my videos are, but Wait One Legal Minute live on Facebook is literally live. It is no production whatsoever. It's just me here on my computer with my knowledge and with my limited technical information. So thank you for supporting. On last Thursday, I had two guests on the show, Jamie Terr and Jabrina Johnson. Thanks again for joining me and sharing some of your legal expertise with the viewers. And we talked about the cost of divorce. We talked about legal separation as well as marital property. I did post two videos, one prior and one after our conversation about the cost of divorce. Those videos and the discussion that I had with Jamie and Jabrina outlined the cost of divorce, specifically the factors that drive the cost of divorce: initial retainers, hourly versus flat fee billing, replenishing retainers, and invoicing. We spoke about those subject matters or things that drive the cost of divorce and how attorneys bill, because it's a recurring issue. People need to know and need to understand how attorneys bill, understand hourly rates versus flat fees, because it helps with the expectation as you are moving forward or moving through the litigation process. Please check out those videos on YouTube. I have a part 1 and 2, and I have part 3 for the cost of divorce. Also, again, I have the live stream, which is on my Facebook page and was also will be uploaded on the YouTube channel with Jamie and Jabrina. Like, subscribe to the YouTube, and continue to follow me here on Facebook Live. So we also talked about legal separation because there is a difference. Some states, we talked about the varying states. We had an attorney that was commenting from the state of Maryland, and in Maryland, sometimes in some other states, there is a requirement for a year of separation. In Georgia, we don't have a time period that you have to be separated prior to filing the divorce. So we just touched on that, and we also just touched on what is considered marital property. So take a look at those videos. Take a look at that live video, which is already up. It stays up, so you can access the questions and the responses and our answers at any time. Today, I am just answering questions from the viewers. It's just me and you. So if you have questions, if you have legal questions, if you have something social you want to talk to me about, please join by just commenting, and I will read your comment and then I'll respond to it. Also, after the show, you can email me at waitonelegalminute@gmail.com. There it is in the on the screen. waitonelegalminute@gmail.com is my email. If you email me, you don't want to comment while I'm going live, please, please, please just email me, and I will read your question aloud and respond to it myself, or get another attorney to be on the show to respond to your question. Also, please subscribe to my YouTube channel. If there are any judges or any attorneys out there who would like to chime in on some of these comments, I have two questions that I did get that I will start out by reading. and sharing today. So if there are any judges or attorneys out there that want to weigh in on the answers, please do so. So a question that I received and I answered, but I wanted to follow up. I wanted to share the question and the answer because I thought it was interesting that it was asked. This was a litigant in a custody battle. And his question to me was, do judges favor litigants who don't have an attorney? This particular litigant, again, in a custody battle, the other party was unrepresented. First of all, if a person is unrepresented, we refer to them in the legal field as a pro se litigant. That means a party in a case who is unrepresented. It's tough to give blanket answers when there's so much discretion that a judge has over any proceedings, but especially custody proceedings. So I cannot give a blanket answer as to whether or not there's any favor given. There is not supposed to be. Okay, judges are, their job is to be unbiased, to listen to the case, the facts, to determine the credibility of the parties, of the evidence, and then to make a decision. But in custody cases, judges sometimes will give pro se litigants a little more latitude than if they were represented by an attorney. Okay, so an attorney is held to a higher standard because we are learned in the law. And so we are expected and we are required to follow the law, follow civil procedure, follow the courtroom protocol. Okay, but if a pro se litigant is there, for instance, in a custody battle, then some judges will give them a little more latitude because the judge also has to allow, the law requires the judge to allow for each party to present their case. So they can't really shut the party down completely because they wouldn't have an opportunity to present their case. So for instance, sometimes the judge will allow the pro se litigant to present evidence that is inadmissible. What does that mean? Well, we have certain rules, we have certain laws that determine what evidence can be presented and can't be presented. And when you have a pro se litigant, they don't know those distinctions. And so the judge may allow a little more latitude in a pro se litigant in attempting to present evidence because they don't know the rules of evidence. So that may look and feel really horrible when you're on the other side with an attorney. You know the evidence is inadmissible. Your attorney is likely making the objection, but the judge will say sometimes, I'll allow it. I understand that, what's admissible, what's not, and I'll weigh the evidence. Okay. Sometimes you'll get a judge that will respond that way. You just have to be patient. If you are the other party, you are represented by an attorney, and you see this much latitude given to the pro se litigant, because what you don't want is your case overturned or appealed because the person did not have an opportunity to present their case. So sometimes the judge will just let it all in. You don't have a jury, no custody cases. Well, in Georgia, I think there is a state that has custody case. I think Texas. Now, if there are any Texas attorneys, I would love for you to weigh in on this. In Georgia, we do not have custody cases in front of a jury trial. They're only bench trials. That means only the judge gets to decide what's in the best interest of the child and make a ruling on your case. I believe I read where Texas actually has jury trials on custody cases. So if anybody is familiar with that, I would love for you to weigh in on jury trials for custody cases in Texas specifically, but any other states that may have jury trials. But in Georgia, we don't, which is why it may not harm you as much, because the court, although they're allowing the evidence to be shared with the court, it's inadmissible, and the court will not put too much emphasis on the evidence. So that's one example, but the court also may allow for the pro se litigant to ask improper questions on cross-examination. So again, there are rules that we have to follow in how we ask questions on direct and on cross-examination. They don't know the distinctions, so they aren't going to know what kinds of questions to ask when they are cross-examining or when they are on direct, what the limitations on the form of the questions on direct are. The court's likely to give them some latitude on that. I will say, though, despite giving more latitude, I can't really say that I've ever seen a court just flat out give favor to the pro se litigant just because they are pro se. They might be a little empathetic, but they're gonna good judges. Good judges that are truly there for the best interest of the child are they're there to hear the evidence, and they're going to let the pro se litigant present a case. So although it may appear that the judge is letting the pro se litigant violate procedure and do what they want, the judge does have an obligation to let each party present their case. Also, I will say this, though, it is not uncommon when a pro se litigant continues to disregard the instruction of the court, because although they're pro se, the court will give them instructions, some guidance on how to proceed. If the pro se litigant continues to disregard the court's instructions, that frustrates the process. And when that frustrates the process, I've seen judges become impatient after repeated attempts to explain. I've seen unrepresented individuals go back and forth with the judge. Never good when you do that. I've seen pro se litigants not just go back and forth with the judge, but have certain tones or reactions or expressions or gestures. That is hurting your case. That's why you hire attorneys. Sometimes an attorney, well, one, they're accountable to you in your case, but they can say, hey, calm down, I got this. Stop showing those expressions. We don't have a licensed attorney sitting there at your table with you. Nobody there to keep you in check. It's emotional. Custody lawsuits are emotional. They hurt. They're painful, and you're emotional. So sometimes it just can be detrimental for you not to have somebody sitting there at that counsel table with you who is learned in the law. I want to pause for a second to read one of our comments. Hello, Kelly, how are you? My daughter is pursuing a degree in criminal justice. She would like to be an attorney. What suggestions do you have for her for internships once the world reopens? Hello, that's a great question. So I've had quite a few calls from people. I'm not sure what larger firms are doing right now because everything is so uncertain. But in general, what your daughter needs to do is to call, send resumes, network as much as she can virtually. I've been doing that. It is possible. Ask people to take meetings with her through Zoom. Reach out to your friends as you're doing now. Ask them if they know someone who is taking on interns for the summer. Is she already in law school, or is she pursuing a degree, a bachelor's in criminal justice? I will say that many law firms will wait until students are actually in law school, especially it's tough to have a college student in because there's so many law students that need the opportunity, need the experience, that many law firms are looking at college students after they complete their first year, so they have a little bit of information, a little bit of knowledge before starting an internship. But I personally have taken on college students before. It hasn't been, I would say, if I were in the shoes of the particular intern, you weren't exposed to much legal information, right? So you're not doing things that you would otherwise do after your first year of law school. So it's helpful to assess whether or not you want to be in that environment or not. But in undergrad, I don't know my opinion, and there are other attorneys that are here on the live. I don't know what other attorneys' own personal experiences in terms of interning or what they see in the industry, if it's helpful, or if they believe that firms are hiring or allowing undergrad students to intern. So she is pursuing her bachelor's degree. So I would say, you know what, I just focus on the bachelor's degree. It is early to start interning. Focus on the bachelor's, focus on getting into law school, into a good competitive law school, and understanding and start learning and researching the different areas of law that she may want to pursue. Um, I I just don't know if of any firms that allow for undergrad interns, but it is worth a try. Reach out to people, ask around like you're doing, ask other attorneys, have her send emails. It never hurts to try. Thank you, Siobhan Tanae Davis. I'm glad this information is helpful. And again, if you have any questions, please just reach out to me on wait1legalminute@gmail.com. And remember to go onto my YouTube channel, subscribe and like and share. Please, it is helpful. This is something that I am very passionate about, just allowing a forum to ask any kind of questions that you have, trying to address them to the best of my ability. And if I can't help you, I will get an attorney that can or refer you or point you in the right direction. The other question that I had from someone, and this was a father. Apparently he had a child support case, and probably after my first show, maybe my second show, he posted a question, and he asked, why are attorneys who represent fathers in child support cases who don't stand up to the judge? My first reaction was, of course, no, wait one legal minute. This is what I do. Family law cases are 95% of my caseload. I wake up thinking about custody, child support, marital property. This is why I do what I do. So although it struck me, I hate that this was his experience. I know plenty. You're welcome, Kelly. I know plenty of attorneys who stand up to the court. That's what we do every day. I can't say what happened in your case. Could have been the specific facts in your case, the laws in your state, the judge, the other attorney presented a better case, or your attorney maybe was not as learned as the other attorney, or was not as learned in that particular law. I don't know. There are so many factors to take into consideration why you had the experience that you had. But as I said earlier, making a blanket statement about lawyers or the judicial system, or how a case will be handled by a particular judge is very dangerous, because one case or one experience does not predicate how subsequent cases will go. I represent both men and women, along with many colleagues, and we zealously represent the interests of our clients. This is what we do. This is what we're passionate about. We want results. We're going to fight until we get the results that we get. And if we don't get them, we know we've done the best that we can. I am, in my firm, and the way I train my staff and other attorneys is we think outside the box. We work hard. We find out the why and the why nots. Why did this particular litigant have this experience prior to us? And if we can change that for them, can we change and can we make them better after they have had an experience with our firm? It doesn't always happen, but I would hope that none of my clients, former or present, can say that I didn't stand up to somebody. I think that would be the last thing that someone might say about my firm, or at least I would hope that. I hate that was your experience with the judicial system, but that is certainly not every father's experience with the judicial system. I commend Georgia on the progressive steps over the past 15 years to even the playing field. There was a time that mothers were favored. Um, in my opinion, those times are over. And they are because enough fathers did stand up with their attorneys or even pro se. Um, they stood up. They stood up for themselves. They stood up for their rights. Eventually, the laws changed, and now judges have become more open. When they see a mother and a father come in, they're on an even playing field. Mothers just don't have prima facie rights to custody. You come in, you present your case, and hopefully the judge makes a determination that is truly in the best interest of the child. Parents are supposed to be on a level playing field when they come to court. It does not happen in every county here in Georgia, so I'm sure it doesn't happen in every county throughout the states. But the laws are now designed, at least here in Georgia, to place the parents on equal playing field. If you have any more questions, please let me know. Again, like and follow Wait One Legal Minute on Facebook. We're going live on Tuesdays and Thursdays. And if you don't comment while the show is live, you can email me at waitonelegalminute@gmail.com, or you can, again, post your comments during the live show or inbox me on the Facebook Live. On my Facebook page, Wait One Legal Minute, but also please like, subscribe, and share our YouTube channel on Wait One Legal Minute. When we are not live, after our last show on Thursdays, we normally post an informative video. So if you have any ideas or you have any questions, or if there is something that you would like us to talk about in our pre-recorded videos, let me know. I will touch on that subject when I record the pre-recorded videos. So I want to thank you all again for the support, for the commentary, for your input, for the questions. Have a wonderful day. I know that it's tough in the state that this world is in, but this is the time to do what you've been too scared to do before. I've done that. I know you can do that. Take this time and grow. That is my challenge to anybody who is still watching the show. Take this time during this COVID-19 season. Take this time to grow. And again, thank you all for joining. Email me at waitonelegalminute@gmail.com, and make sure that you join, like, and subscribe to my YouTube channel. Continue to follow me on Facebook. I appreciate you. Thank you. Have a good day.